Hello, my name is Kenneth Pascal. I'm with the Alabama Family Rights Association, and I'm here with Mr. Green, Attorney Green. I'll ask him in a few minutes to introduce himself, but we're going to have do several Q&As here. Probably take about 7 to 10 minutes. But it's dealing with a piece of legislation we've been working on for about 10 years. It's called the Children's Equal Access Act. Attorney Green, please introduce yourself and let us know where you're from, and then we get started with our questions.
Well, first off, thank you, Kenneth, for having me today. I'm Attorney Kalif Green with Kalif R. Green, Attorney at Law out of Coleman, Alabama. I do most of my practicing in Coleman, so that's where I usually practice. I do venture out a little bit, but my practice is based in Coleman.
Right, okay. Well, I definitely appreciate you taking the time out of your schedule there, and I remember meeting you years ago. I think you was a second year grad.
Second year in law school, yeah. It's been, 6-7 years now, so it's been a while, but yeah, I remember back then, I was inspired by the work you do. I think I even scheduled you to come back a couple of times and speak to our different organizations I was a part of, so I've been really impressed with what you all do, the legislation that's been trying to be passed, and I'm glad to be a part of it.
Okay, well, definitely, thank you. And I tell you, we're gonna dig off into our questions, and that way we can hopefully our audience they will leave away with more knowledge than they came in with.
Okay.
And the first question: what is the problem dealing with family law, and what's the impact on kids when they lack a consistent relationship with two loving parents?
Well, Ken, the data tends to show, and this is coming from the Alabama Department of Human Resources and the U.S. Department of Health and Human Resources, that children who come from a single-parent home compared to a shared family home tend to make up 63% of youth suicides, 75% of juvenile drug abuse, 85% of youths in prison, 71% of school dropouts, 71% of teen pregnancies, and 90% of homeless and runaway children. Those numbers are staggering. Those numbers are eye-popping, and if that was associated with anything else, it would be looked at as a public health crisis. And so the impact that being in a single parent home compared to having both parents involved is detrimental to the children, and the data tends to show that.
Right. And I agree. And I tell you, that's what keeps our organization volunteers going, because we do really think this is a public health crisis and need to be dealt with immediately. And so this bill called the Children's Equal Access Act, we definitely asking our listeners and our lawmakers and the legal community to support this piece of legislation.
Yeah.
Because we think it is a public crisis what we have now. And so could you tell us, summarize the bill, how was the bill created, and then what the bill does?
So what this bill is and what it does is it incorporates the Alabama Law Institute legislation that's previously been enacted. But what it does is it incorporates the social science data with some existing case law regarding child custody. The main goal of this bill is to protect the approximately 40,000 children in the state of Alabama each year who are being placed at risk by losing one of their two fit parents because of the outdated practices and systems that we have in place in our legal system.
Right, okay. Well, I definitely appreciate that. And you mentioned about this bill incorporate the Alabama Law Institute bill, and I had the opportunity to sit in on several of their meetings as they generated their bill in 2017.
Okay.
But it was missing a couple key elements, and since this bill has been updated to, as you mentioned, incorporate the social science data that looked at about a quarter million of kids,
yeah,
and says if we create more of a balance, kids have better outcomes. So I definitely appreciate the work of the Alabama Law Institute there.
Of course.
And appreciate the feedback from the other people in the legal community, judges, lawyers, social workers. We have put together a very diverse group committee that actually felt this is best to incorporate the Law Institute bill language, the social science data language, and here we are with a good piece of legislation there. And I think you mentioned about this will impact approximately 40,000 kids each year.
Yes. And
So
if
they
you
have a
go
good
back and look
outcome.
at the data since 2008, in a 10-year span between 2008 and 2018, approximately 426,000 youth in the state of Alabama were put at risk because the legal system and the practices that we have in place are so antiquated that they're not really using the best outcome for the child. We say the best interest of the child a lot in the legal profession. That's what we say we base everything on. But the practices we institute and apply doesn't always give us the best interest or the best outcome for the child. So with this legislation, it's going to be very important to get a starting point to helping judges and lawyers and even fit parents figuring out where we should need to start, how we can move forward, and ways we can work together to make sure the child is in the best possible outcome.
Right, and I think you mentioned 420 some thousand kids over the last decade that since we've been trying to incorporate this legislation, but we have pretty much let them down by
Yep.
not passing good legislation based on social science data. And I'm really excited for the next legislative session because I believe that our lawmakers is going to do the right thing for the next generation of kids there. But once this legislation is passed, how would that shift the role of the federal law attorneys and counselors, and what would that look like?
What will happen is it will give, in my opinion, family law attorneys and counselors and even judges, it gives them a good solid starting place. It gives them a guideline. We can say this is where we're starting from, and the reason we're starting at this place is to reach the best possible outcome for the child. It's not, nothing in there is going to mandate how judges are to act or how they're to view cases, but it gives us a strong, solid starting point. And for me as an attorney, what that does is it gives me the ability to relate to my clients, okay, this is where we're going to start from because what we're trying to end up at is the best outcome for the child. So it gives me a good starting point. It allows me to interact with co-counsel better because we're both working from the same starting point and we're not coming at it from a adversarial winner loser take all type of mentality.
Right. And you mentioned starting point. The neat thing about this legislation, it creates a starting point. It creates a rebuttable presumption that joint custody is in the best interest of the child.
Yeah.
And then it goes further and define what joint custody is as far as the physical custody. It says equal, not 50-50. It says equal or approximately equal. So give that buffer starting point, and I like that. Now, but with that presumption, what are some of the things that the opponents or people that might quite not support this legislation, what are some of the things they're saying to justify their opposition to it?
Well, some of the things that are being said, and I think one of the key things that are being said is that the rebuttable presumption takes away the judge's discretion, and that is far from the truth. This legislation will give us a guideline. It will give us a starting point, but what it will do for judges instead of taking away discretion is it gives them a roadmap to say, hey, this will make my job a lot more efficient. It allows me to be more concise. It allows me to look at each case individually, knowing though that each case will be, not the same, but okay, this is where we'll start from. And then from there, I can take each case and, go about it accordingly based on the facts that are presented in each case. But what I think it does is it gives a judge a better way to implement what they want, how they want it to go moving forward in the process. After the process, it gives them that good, stable guideline, and even to say, hey, counselor on this side, this is how we're going to operate. This is what we're going to be looking at. This is why we're going to be looking at it. Because again, the goal is to get the best outcome for the child. Another thing that has been brought up by opponents to the legislation is that this bill is going to mandate 50-50 custody, and that's not true. The data would tend to show that there is a frame of about 35 to 50% that would fall into the equal to approximately equal time frame. 50-50 would be ideal in a perfect world, but we know that's not the case for everyone. So what we're doing is we're not mandating that there be 50-50 split time or 50-50, custody or anything of that nature. What we're saying is let's start at this point, and if we have to work outside of those parameters, that's fine, but we're starting here because we're ultimately trying to get to the best outcome for the child.
Right, and I appreciate you highlighting the 50-50 mandate because actually in 2011, the legislation at that time, it did have that language in there that mandated 50-50 for every single case.
Yeah.
And the good thing about that legislation, it started a conversation. Here we are today.
Yeah.
And we actually, through talking with the judges, the lawyers, and other people in the legal community, even counselors, along with the social science data, we found out that, well, let's need to modify that language.
Yeah.
And so now the bill language is, it's a presumption that equal or approximately equal is in the best interest of the child. It's more in alignment with the social science data.
Yeah.
So this is not the Alabama Family Rights Association saying this was best. The social science data is saying this was best. How close can you get to the equal? And sometimes every other weekend might eventually end up being the best for that particular family situation. But
of course,
for best outcomes, we have goalposts. Say, okay, try and get into that 35%, as close as 50% as you can, based on the facts.
And
case.
Like we said, 50-50 would be ideal. But one thing this legislation does, and one thing we understand about it, is we don't want to handcuff judges to giving out, again, cookie cutter custody agreements, because if we mandate 50-50, we're pretty much taking it back to where we are now, just on a different end of the scale. So what we're trying to do is we're trying to give the judges a solid piece of information to say, look, let's start here. Or for the judge to look at it and say, okay, this is where we're going to start, because these guidelines are going to keep us all within the realm of where we need to be, because what we're trying to do is get the best outcome of the child. So the 50-50 lane, like I said, 50-50 would be ideal, but we do not want to handcuff judges to make them only consider the factors that we're, introducing, but give them still the discretion to look at each case by the facts and apply what they see best based off each case and what it presents.
Right. Now, we have heard at one time there was a concern about domestic violence. I know in 2018, several people from different domestic violence groups, they was opposed to the legislation because people put out inaccurate information about people that would abuse their kids would have automatically equal access to their kids.
Yep.
But since that, what have we done? What have this legislation done to try to address those concerns?
Well, first and foremost, this legislation doesn't change anything that's currently enacted as far as domestic violence in the state of Alabama. The 2020 version of the Children's Equal Access Act actually includes, and I'm going to quote it verbatim, this bill would specify that nothing in this act shall be construed to limit the domestic or family abuse provisions provided in Article 6 of Chapter 3, Title 30, Code of Alabama, 1975. So basically, this legislation acknowledges that there is already statutes on the books as far as what should happen, how it should go when a child is in a situation where there's been domestic violence. This bill does not look to change any of that. This bill does not look to interfere with any of that. This bill is simply to address situations where there are two fit parents, and we're trying to figure out, or the judge is trying to figure out, how do we get to the best outcome, which is equal or approximately equal time with both parents. Mom and dad might not be able to get along, so they might not be able to figure it out, but this legislation will give us a better way to get a starting point of where we need to go to get to the best outcome for the child.
Right. And once again, I really appreciate you just highlighting that about the domestic violence code, because I think I was surprised last year talking with several people in the legal community. Is that, Kenneth, you know that there's already code that addresses domestic violence code. It creates a presumption that if there is domestic violence, the child don't reside with their parent.
Exactly.
And I like, this bill actually makes the code even cleaner, more consistent throughout the board, by using a rebuttable presumption language.
And that's the key thing with this legislation. It's all about consistency, and that's what it's trying to do. It's trying to get a uniform, standard approach. It's not mandating that everything has to be 50-50, but if we can all start from the same place thinking about the best outcome for the child, we can approach it better, and the numbers will start trending in a better direction for the children of Alabama.
Right. And I like that for us saying the Cheers Alabama, what would that look like? So we're close with this last question. Well, first let me go back. Another neat, good element, I call it a tool, this bill require, empower the courts with is it require the parents either together or individually to submit a parenting plan.
Yeah.
Where you're saying based on my work schedule or my lifestyle, here's what is best for me. So that way you require the parents to do it individually or together. Yeah. And that's another tool the courts never have had in the history of Alabama.
Yeah.
To give them a better, instead of doing, once again, a cookie cutter approach every weekend and mom or dad working weekend shifts, well, that doesn't work.
Yeah. And the good thing about this legislation is, and with the parenting plan, the good thing is we want to shoot in that ballpark of 35 to 50% as equal to approximately equal time with both parents. But based off the family situation, the family dynamics, if time needs to be different, if it does need to be every other weekend, if it is once a month, or if it is, however it might be, that parenting plan allows you to say, okay, this is what I'm comfortable with. This is what works for me, and hopefully we can agree to say, okay, your parenting plan is submitted and it's okay. My parenting plan is submitted and okay, and it's okay if it's outside of the 35 to 50%. We're shooting for that, but we understand life happens. Things happen that are out of our control. So, the parenting plan is key because it allows each parent to set the tone of how much they want to be involved, when they can be involved, and ultimately what we're trying to do is reach the best outcome for the child. So with those parenting plans in place, we get a good starting point of where we think we should go with the custody agreement.
Right. And like I said, we opened this Q&A up with talking about the impact on kids. I think you mentioned about the 85% of our youth sitting in prisons from one parent involvement or one parent homes and so forth. But when this legislation passed, if the goal is to maximize the child time with both parents, if we're able to do that with the next 40,000 kids, what would that look like? What would the outcome look like for the next generation of kids?
Well, the data will show, Ken, that if for the next 40,000 kids, the next generation of kids, the data shows if we're truly working together to have shared parent families, that mom and dad doesn't necessarily have to be together, but if they're both engaged with the child, if they're both actively participating in the child's life, the data shows that child's grades will be better in school. That child will be less likely to abuse drugs and alcohol. That child will be less likely to deal with mental illness and things of that nature. That child will be less likely to be a school dropout, have teen pregnancy, things of that nature. So the data shows that if we can get this legislation passed, and if we can get the narrative changed, and everybody thinking on the same page, that for the next generation of children, the next 40,000 children in the state of Alabama, we can start putting them on a better path to success. We can start giving them better opportunities that wasn't afforded to the 426,000 children of Alabama in the past 10 years. We can start doing right moving forward so that we give these children a better opportunity. We give them more hope, but more importantly, we keep them engaged with two fit parents. And I think that's the biggest thing that people need to take away from this legislation, that it's about two fit parents. And how do we keep the child or children engaged with both fit parents? Because as we talked about here now, the data tends to show that is key, is to have two fit parents involved and engaged in a child's life. So this legislation would definitely do that. I think it would be great as far as changing the narrative. It's not going to change everything overnight, but it will be a starting point, and it will at least get the dialogue started, the conversation started, and we can start moving in a better trend for these children.
Right. Well, I agree with you there, and thanks for your time again. And as I mentioned, my name's Kenneth Pascal with the Alabama Family Rights Association there. And if you'd like to know more information about this piece of legislation or anything about the best outcomes for kids, we'd be more than happy to share more information with you there. Visit our website at alfra.org, or you can reach us on Facebook, Alabama Family Rights Association there. And Mr. Attorney Green, if people like to know more information from a legal standpoint about this legislation, how can people contact you?
You can reach out to me by my business phone, 256-339-7878, or by email, which is, again, my name, Kalif R. Green, spelled out, at gmail.com. I do not have social media. I'm more old school. To be as young as I am, I don't do social media, but you can call me or email me at any time, and I'll be quick to respond. It's Kalif R. Green, attorney at law, and I'm based out of Coleman, as I said, and if you give me a call, I'd be glad to help and see what we can do.
All right. Well, thank you for your time again, and thank y'all for learning more about the Children's Equal Access Act. And thank you for your time. Okay.